Good. Let's start with a second session. Dr. Natalia Scavuzzo from Genoa on interpreting legal statements, different points of view in describing the law.
Thank you.
You have half an hour.
Okay. I have, there is a handout. I don't know if everybody has it, but it's around. So if you can get one, it will be easier to follow the presentation. So I will talk about the meaning of legal statements, and what I understand for legal statements are statements that convey what a legal order obliges, permit, or prohibit people to do. So our statement about what law is. So as most of the legal discourse, legal statements use expressions such as obligatory, permitted. So this raises lots of problems to understand what is the meaning for legal statements. When I say in my work is that usually the traditional view of understanding what is the meaning of these statements is to distinguish between statements that express norms and statements that expresses norm propositions. The thing is, I believe this is not enough to understand the meaning of legal statement, and I think we should notice a further and fundamental ambiguity. There is the ambiguity between if a statement can be an internal statement or an external statement. What I suggest is that there are two different distinctions and that we can combine them so we can actually have 4 different kinds of interpretations for legal statements. I will go very fast on the first ambiguity because of time, so I will just say that it's almost accepted by every legal theorist that deontic sentences can have 2 meanings. They are usually used to express a norm, or they can be used to express a norm proposition. So if they express a norm, we usually say that they don't have a true value, but when they express norm propositions, we are disposed to say that they are true or false. So although there's like an understanding about this, there are also some disagreement about what is the meaning of a norm proposition, and because of that, what makes a norm proposition a true proposition or a false proposition. So my example is euthanasia is forbidden in Italy. That's the example I have in number 1. That is my legal statement. And I say, okay, maybe everybody will agree that this is a true statement, but we can maybe not agree what it makes it a true statement. So in my work, I analyze 3 different ways of understanding norm propositions. I will not discuss them here now, but they are how Boolean will understand a norm proposition, how Wastini or a realist approach will understand norm propositions, and how Kelsen will understand a norm proposition. So these are like statement 2, 3, and 4 on the handout. These are my 3 examples of norm propositions. So the main thing about this distinction is that I think all of them agree that the distinction between norms and norm propositions is based on the illocutionary force of the statement. And I think they disagree of the meaning of norm proposition, and specifically which are the true conditions from norm propositions. So now I'm going to emphasize the distinction I think is more interesting and maybe a little bit more controversial about internal and external statements. So the internal-external dichotomy has been largely used in philosophy and in jurisprudence, and not always with the same sense. And in legal theory, it was Hart, which makes it very popular, even though also Ross has used internal and external point of view. But when I'm going to propose here, is an argument based on heart, but I don't want to discuss if it is the best heart's interpretation or not. I think it's a possible one, and I think it's better than the standard one because it allows us to see some things about the law and to clarify our thoughts about it. So what I say is that the standard interpretation between internal and external statements in Hart's view seems a little bit analogous to the distinction between sentences that express norms or norm propositions. Because internal statements are statements that are thought to have some kind of commitment or moral endorsement or like predisposition to act conform a rule. So internal statement under this view will be statement without true values. Even rather, external statement will be statement that refers to rules, that talk about rules, and they can have true value, and that's why they can underpin a theoretical discourse about the law. When I want to say is that the distinction between internal and external statement, for me, is not necessarily related to the locutionary force of the statement, and rather is related to the context in which we ascribe a semantic meaning to a statement. So I have to make an assumption clear before continue the argument. That is that I understand every social practice and every practice that we can ascribe meaning to it as a rule-dependent practice. So every action or every sentence or every activity or practice that we think that has some meaning is always rule-dependent. In this sense, also law is rule-dependent, but not because law puts norms to people to behave or not in certain ways, but if we believe that law is a practice which has some meaning, it's a rule-dependent practice. It's what it makes law similar to other practices like language or games. So, to understand a little bit about this, we have, when we confront a social rule, we can distinguish different points of view through our rules. So we can have an external point of view or an internal point of view. So the internal point of view depends on the acceptance of rules. What is the acceptance of rules is also a concept that have arisen lots of questions. I'm not going to also discuss all the possibilities about what acceptance is. I'm just going to take a minimal concept of acceptance, and I will consider acceptance and the possibility, as the understanding, as the comprehension of when a conduct or state of affairs fits a standard, and that certain conducts are acts of deviation from that standard, and because of that, these conducts are facts that justify the critiques. So here, acceptance is just to understand when a conduct fits or not fits a standard, and to know that because it does fits the standard, that conduct deserves a critique conforming that particular standard. So we can accept because different kind of reasons, for moral reason, aesthetic reason, prudential reasons, but still it's possible to think of the acceptance of a rule without any justification for it, without no reason to accept. So the acceptance of rules does not necessarily imply moral commitment nor any kind of commitment. Acceptance is just the understanding when a rule, an action or a conduct fits a standard. If we are able to do this, we understand what the rule is. We comprehend the rule. In this sense, we accept the rule. If we are able to do this, we are in this internal point of view, and we formulate internal statements. Whenever we do not accept determined set of rules, we are in the external point of view, so we formulate external statements. So, once again, to make it clear, the distinction between internal and external statement depends on the acceptance or not, or a set, or the acceptance of some set of rules. The relevant rules to determine if a statement is an internal or external statement are the rules accepted by who uttered the statement. And generally, these rules that are accepted by the person who uttered the statement are presupposed and are not expressed in the statement. So, a peculiar case is when statements refer to rules, or when a statement talks about rules, we should distinguish between which are the rules that the statement refers to and which are the rules that are presupposed when we are uttering this kind of statement. So, if we think about specifically about law, I believe that we can also take Hart's proposal and think about, talks about the rule of recognition. The rule of recognition in Hart's proposal is a rules that contain the criteria to identify which are the rules that belong to a legal system. So we talk about the rule of recognition, but in reality it's a set of rules or a set of criteria. It's not just one rule. So when we want to identify which are the rules that belong or not to a legal system, we must apply the criteria that this rule of recognition provides to us to identify which are the rules for the legal system. So when doing this, what I think that we can think about is that every time we say that a rule belongs to a legal system, we are making an act of application of the rule of recognition. And sometimes this is presupposed and is not made explicit, but every time we say a rule belongs, or we say a rule does not belong to a legal system, we make this application of the rule of recognition. I don't want to enter also another discussion about if the rule of recognition is a conceptual rule or is a rule that guides behavior. I will not say that there are the same kind of rules, there are some differences, but what I think important is that they are both social rules and that they have the main things about rules are common to both concepts of rules. Rules that guide conduct and also conceptual rules. So that's why we can apply the concept of acceptance to both, and that's why also we can understand what is the internal and external point of view to both kinds of rules, conceptual rules and rules which guide conduct. So I think the notion of acceptance and the distinction between internal and external point of view can be applied to both, and this mode of similarly understanding both kinds of social rules, I think it's exemplified by Hart when he says that a typical internal statement is one that makes use, and in a generally implicit way, of the rule of recognition, in order to identify which are the rules of the legal system. And here he links the rules of recognition to the rules of scoring of a game, where generally this rule, although it's not formulated, defines which are the activities that are parts of the game, and players, and maybe if there is some referees or authorities, use it to define what are significant parts of the game or different acts during the game. So he says that expressions such as goal or out are internal statements that make an implicit use of the rule of recognition. So all this was to say that even if one says that conceptual and regulative rules are different, the distinction between internal and external statements can be applied to conceptual rules as well. So now, what I want to explain is, I have an example, statement 6 and 5, and they are two different interpretations of our initial statement 1. One is an internal statement and the other is an external statement. So the external version is number 5, that people, this statement is made by someone who do not accept the rule of recognition. And this person sees that some people do it and use it to identify which are the rules for the legal system. So the statement 5 says, people related with Italian law say that euthanasia is forbidden in the Italian legal system. So this statement refers to a rule, but only in an indirect way. Rather, the object of this statement is other people's recognition of the rule. So this statement does not identify which are the rules of the legal system, but rather that a group of people make assertive speech acts about which are the rules of a legal system. Whereas, on the other hand, you have number 6, that is the internal version or the internal interpretation of our statement 1. So statement 6 says, there is a rule in the Italian legal system that prohibits euthanasia. There is like a short version of the whole internal statement that would be also, we can include also which are the criteria or the rules we are accepting. But the thing is, more of the time, these rules that are accepted to formulate internal statement are not formulated, are just presupposed. So this version refers directly to a rule, and in order to do it, it has been necessary to apply the rule of recognition. Thus, this statement is about a specific rule, but likewise, implicitly accept other rules, accept the rules that are the rule of recognition. So, having made this, I have pointed out that there are two kinds of ambiguities that a legal statement, like one, can have. This sentence can be used to express a norm or can be used to express a norm proposition. At the same time, this sentence can be expressed from an internal point of view or from an external point of view. What I'm trying to make in this work is to combine the two analyses and say, okay, if we combine it, we can have 4 different interpretations for my first statement number 1. And this external descriptive statement, it can be an external prescriptive statement, an internal descriptive statement, an internal prescriptive statement. And then I try to analyze statement 1 in each of these versions. We can start with the first one, external descriptive statement. So if we understand euthanasia is forbidden in Italy as an external descriptive statement, we have to consider that this is the product of an assertive speech act. So it can be true or it can be false. But also, the person who utters does not presuppose the validity criteria of the legal system, so does not presuppose which is the rule of recognition. So this statement will be external in relation to the rule of recognition. Does not mean that it's external in relation to all set of rules. It's only external in regard the rule of recognition. So we can see that my interpretation number A, that is external descriptive, it will be analogous to statement 5. People related with Italian law says that euthanasia is forbidden in the Italian legal system. So it's an assertive speech act, and does not presuppose the rule of recognition. And I wonder, for example, if statement 3, that is what is a norm proposition in a realist view, like for example Guastini, can be also understood or not as an external descriptive statement. When I think is that there are two possible interpretations of statement 3, and one of them it can be understood as an external descriptive statement, and in this, in Italy, generally judges decide to impose penalties of imprisonment to those who carry out acts aimed to conclude someone else's life. In these interpretations, here the judges are identified only in an indirect way. So judges can be what people related with Italian law say that are judges. So in this case, this will be a totally external statement. There is also another possibility, because if judges are identified by applying some rules of the legal system, the problem is here that we are presupposing some rules of competence. So also we presuppose the validity criteria of the rule of recognition, and in this case, statement 3 cannot be as long, cannot still be a total external descriptive statement. It will have to be an internal descriptive statement. So we move now to talk a little bit about the external prescriptive statements. So this statement express prescriptions. So these sentences express prescription. And similar to the previous one, they do not presuppose the validity criteria of the rule of recognition. So in this way, external prescriptive statements are more likely to be statements about how the law should it be, not how the law is. And I thought about another possibility also. For example, when we want to attribute meaning to some term or sentence in the law, that it has no meaning in the frame of meaning established by the legal practice. So when we establish meaning to these terms or sentences, I think we are making also external prescriptive statements. Also, we can think the possibility, and we can discuss about it, when we have, for example, when judges solve cases where there's legal contradictions or legal gaps. Here they make external prescriptive statements. And now, moving out to the internal statements, the internal descriptive statements, I think they are the more interesting kind of statements to describe the law. They are also the product of an assertive speech act, so they can be true or false, but they presuppose the validity criteria of the legal system. So, an example of statement 1 as an internal descriptive statement will be as statement number 6. There is a rule in the Italian legal system that prohibits euthanasia. And I think also statement 2 and statement 4 and one of the possible interpretations of statement 3 can be included into the category of internal descriptive statements. And the reason is that I think all of them are engaged in the same kind of activity, that is to describe which is the legal system. And they are internal in the sense, I think they believe it's important to accept the same kind of rules that the participants in that practice are using to describe which is the legal system. Because if we describe, like with external the interpretation of statement number 3, if we consider it as a total external descriptive statement, we can say, okay, the rules that we are following in order to describe these legal systems are not the same rules that actually the participants are using when they identify which are the rules that they are following. So, lastly, I will say something about the internal prescriptive statements. And these are statements that express prescriptions, but they also presuppose the rule of recognition. So, for example, we can say that the statements made by authorities when they are carrying on their functions, they can be understood as internal prescriptive statement. Or we can also think about a legal theorist that is interested in knowing what the law is, and she uses the validity criteria of the legal system, and so she identifies some rules as part of the legal system, but she also believes that being a rule of the legal system is a reason for action. So this statement under this interpretation can be understood also as an internal prescriptive statement. So another possibility was, I was wondering if statement 4, that is a non-proposition under Kelsen's view, could be included or not under this kind of interpretation. And we can discuss it also, but I think we cannot include it there, because although the non-propositions for Kelsen describe an ought to be, they are still describing, and they can still be true or false. And the fact is that they don't describe facts, but just describe the act of will, the meaning of an act of will. So, just to finish, I will summarize, and you have also the conclusion in the back of the handout, that it's been argued that in order to grasp the meaning of legal statement, 2 different ambiguities should be considered. The first one concerns the illocutionary force of a given statement, and is present in all deontic statements, and forces us to distinguish between statements that express assertions and statements expressing prescriptions. The second ambiguity is a semantic one that affects all linguistic expressions, not only legal statements. And this second ambiguity forces us to determine the context of utterance of the statements, to determine which rules are presupposed when uttering them. And in order to determine the context of legal statement, it has been proposed to use the validity criteria of a legal system under the form of the rule of recognition. Finally, in combining those 2 ambiguities, it has been suggested that there can be at least 4 different interpretations of legal statements. And this analysis I have presented here provides a helpful way to understand, I think, some of the perplexities in analyzing the legal discourse. In particular, I presented this new way of these 4 kinds of statements, and I think this work can lead us to other further discussions that can be very interesting concerning how we should determine the relevant context of legal statement and how we then justify those methodological choices. So, I'm done.
Thank you very much. We are